Good morning, Your Honors. If you don't mind, I've got a little water. I've got a head cold in case I get.
Water's just fine.
Thank you.
We've got water as well.
Your Honors, this is an appeal as of right from the Circuit Court in Williams County on a post-divorce action. The issue really, or issues are really pretty straightforward. This post-divorce action that was originally, there was an original action.
Do you want to save time for rebuttal?
Yeah, I'm sorry. Yes, 5 minutes, Your Honor.
Okay.
Thank you for reminding me. This action started as a post-divorce action that there was a contempt brought, and that was resolved by the parties. And then Dr. Boone afterwards filed a declaratory judgment action because there was a dispute as to whether he had paid the amount that was owed for past child support and other matters. That matter was resolved by admission, by consent judgment, essentially by Dr. Boone, where he agreed that yes, he underpaid the amount from the prior action by the amount of $5,740 some odd dollars. Subsequent to that, he filed an amended declaratory judgment action and a petition to terminate or modify his alimony obligation. After a lot of discovery, a lot of litigation, that matter was dismissed at the day before trial, or essentially on the eve of trial, without prejudice. The trial court did not grant my client attorney's fees, finding that she found that there wasn't a basis for attorney's fees and that she was not a prevailing party. We're here today because we respectfully submit that this case is distinguished somewhat from the Colley case because the language of the marital dissolution agreement, which controls in this instance whether or not attorney's fees should be awardable, is different than your normal marital dissolution agreements. It does not use the word prevailing. The MDA from 2013 uses the term successful. It actually says unsuccessful, but the successful party is entitled, according to the MDA, to their attorney's fees. So the question in this case is, which is distinguishable from the Colley case that that Dr. Boone relied on before Judge Hood, was the distinction here is a prevailing party the same as a successful party? And the way I would respectfully submit that it's not always the same thing, because in this instance, if you look at it like it's a football game, Dr. Boone had the ball. Dr. Boone proceeded for the entire life of this period in this lawsuit, and then he punted, essentially. His non-suit was a punt. My client was successful, and so that's different than prevailing because, yes, he could refile. He could have refiled. He did not do that. As of today, he has not refiled this action. And so what we have is my client, under the terms of the marital dissolution agreement, was successful. She successfully fought off his attempt to, number one, not pay any additional money that he was owed according to the marital dissolution agreement. And then he sought new relief in the same action where he sought to have her alimony terminated or modified, both of which he essentially capitulated and punted. And so
Wait, you argue that it's different, the successful party is different from prevailing party, but then when you're arguing, you keep saying she's the prevailing party. So how do the concepts differ here?
They differ because prevailing, they can be synonymous, but prevailing, there's no finality. And so at this point in the litigation, my client is successful. There is no pending case now. So when he non-suited without prejudice, he, of course, has a right to rebring that within a year under the savings statute or the non-suit statute. And so there isn't a final order on this issue, if he wanted to rebring it, that says, yes, the alimony can be terminated or can be modified. So we don't have that. So that's still potentially legally exists. However, under the marital dissolution agreement, at this point, my client is successful. Now, should she have to wait? And I have not found a case that says this, but should she have to wait until the time has lapsed for that issue to become a final dismissal? That at that point would be on the merits to her.
I was going to say, doesn't it require a decision on the merits? And we don't have that in this case, do we?
We don't have that, but I would respectfully submit this instance is distinguishable from a termination on the merits, for instance, like in a malicious prosecution case. We don't have that. What we do have is, which is distinguishable, and that's based on the language within the marital dissolution agreement. It specifically uses the word successful. Well, how do you define success? And I respectfully submit Your Honors should interpret that word differently in this context, because at this point, I think it is undisputed that she is successful now. He mounted his offense. He had the ball. He tried to seek the termination of of her alimony or a modification thereof. And at the last minute, he capitulated and he punted. It would only be a fair interpretation of the marital dissolution agreement and that word successful to say she was successful at that time. If you looked at it in the football context, if a defense holds the offense off and they don't score, that's a successful stand on whatever that time of possession is. The same should be interpreted in this instance, because even though there is no finality, that's where I respectfully submit the distinction is between the term prevailing and success. Prevailing is success, but success is not always prevailing. But we have at this point in time success for Miss Boone, who had to suffer through and defend these challenges by Dr. Boone. And so at the end, as we stand here today, there is no case pending against her seeking to terminate or modify. And Dr. Boone capitulated and he dismissed his case. And so respectfully, I respectfully submit that the term, there is that distinction on the term and the use of the word success. And that word, that's what distinguishes this case from the Colley case, because I've not seen another case that talks about success in a clause in a contract that it's usually the words used prevailing that I've always seen, or I've never seen the word success used. I didn't draft it, but I think in this instance it's appropriate, and there is a distinction between the term success and prevailing. And I respectfully submit it was error for the trial court to consider these interlocutory orders that had to do with some discovery disputes and grant relief on that to Dr. Boone and on one point to Miss Boone, but then at the end of the day, she gave no weight to a admission, an order that Dr. Boone admitted to. I underpaid the $5,740 some odd, and then at the end, that's an admission when he just dismissed his case, particularly given the fact that he hasn't rebrought it. So respectfully, I would submit that based on that, respectfully ask the court to reverse the trial court and remand it.
All right, thank you, Mr. Preston. We'll hear more on rebuttal.
Thank you, Your Honor.
Ms. Smith? Good morning.
Good morning, Your Honors. Morgan Smith of the Nashville Bar. And Your Honors, I'm just going to jump in because I think this was a little bit of a pivot from what was in the brief, which is this argument that successful and prevailing are not necessarily the same thing. And when I'm looking at the brief, even Miss Boone herself, the appellant, stated that pursuant to the parties' marital dissolution agreement, she was the successful and prevailing party. The prevailing party, is the successful party. I hear their football argument, but if your defense is successful at stopping that 4th and goal, that doesn't mean you prevailed. You don't necessarily win the game because you might have been successful on that one point, and I don't think that is exactly the right thing. I struggle to see how prevailing and successful are not synonymous. A successful party prevails just by definition. So how could you have one prevailing party and one successful party? I know that appellant is arguing that they should also be construed as the prevailing party, but that's an abuse of discretion standard. I think the trial court was very clear in their basis of why they believed Dr. Boone to be the prevailing party, and I don't understand how, if you're the prevailing party who filed a petition for a declaratory judgment that received that declaratory judgment, how he would not also be the successful party. I agree, this was some pretty nasty post-divorce litigation.
Wasn't he seeking to terminate her alimony?
So he filed an amended petition later to modify or terminate the alimony. And it is a little concerning. I practiced nearly entirely in the field of domestic law at this point. It is very common in these modification cases that they get dismissed very close to trial, because what the current case law is to modify or terminate based on cohabitation requires that at the time of your trial, the cohabitation be happening. So it's very common that at the time that you file a petition, there is cohabitation going on. Not sure if that was here, I wasn't the trial attorney, but that's very common. To say that you can, there's already a certain measure of gamemanship that is just, frankly, it's just allowable under the case law, and I think attorneys would commit malpractice if they didn't, utilize what is available to them. But to say that then you could litigate, especially a case like this where it took 17 months just to get a number that was, I think it was $5,746.34, and that's really stuck with me because that's probably less than what Dr. Boone had to pay for his initial retainer to Attorney Hayes. That is a de minimis amount of money in comparison to what these parties paid for their attorney's fees, just trying to get Miss Boone to give up that number. But I sort of diverted there for a second. But to say that someone's successful because something's non-suited, and then you would create a situation where we are encouraging litigants to go forward with, in this case, what I think had a trial with a jury demand on it that was going to take multiple days, spend all of that money just to show, hey, this was a good faith effort. She just moved out right before trial. That's not what we want to be doing. But I find it hard to believe that successful was not just used interchangeably with the term prevailing. We frequently look at case law and input what case law is to these marital dissolution agreements. They're contractual, but within certain rules and within certain statutes. And I think even in how the parties themselves handled it at the trial level and even in the briefing, successful should be synonymous with prevailing. And I think here it was absolutely not an abuse of discretion to find that Dr. Boone was the prevailing party. And I think if it got remanded to a trial court, they'd probably find that he was the successful party too. I also think, going back to the law about non-suiting, I think just because it says successful doesn't mean that same law doesn't apply. The purpose of a non-suit is it restores everyone to where they were on that issue.
I think what I heard you saying.
Probably in a big circle.
Well, I could be confused, but I think what I heard you saying was that if you file a deck action and you get a result, even if it's that you owe money, you're the successful party.
I think technically, yes.
Because you got the deck action result.
It's something happened to require the deck action to be filed, right? Now, in this case, I think especially so, because what Ms. Boone was originally asking for was significantly more than what was finally put in that final order. I think
true.
$250,000.
But he did end up paying, so that sort of makes me try and work through this, how one could be successful if one has to pay. But I see
Well,
your point.
I think it might be a little different if what the amount was he had to pay was $250,000. But we're talking, it wasn't the $250,000 that Miss Boone was asking for.
Well, Miss Boone filed a counterclaim, did she not, initially
She did.
to the dedication? And how much was she asking for in the counterclaim?
It was $250,000. It was an unspecified amount that he owed. And that's what led to the months and months of the discovery litigation, is that it didn't specifically state in her response.
But during the pendency of that petition, didn't he pay $380,000 in alimony arrearage?
And let me clarify. There was originally, predating this petition for declaratory action, an action that was brought by Miss Boone. That was dismissed, and that was
It was
where the
dismissed.
$380,000.
It was dismissed after he paid $380,000.
Correct.
Okay.
This was a new action that was after that action with the
And your
$380,000.
position is this action is independent of the prior one.
Correct. And I wasn't the trial attorney. I don't know why they handled it the way they did procedurally, but that matter was done. And my understanding from the declaratory action is an agreement was unable to be reached that he had satisfied the obligation, which I think was very smart for him to file that petition for declaratory action, because if you don't, you're putting yourself, especially with the history of these parties, at risk of another contempt action. Actually, that is what Miss Boone filed, another contempt action, stating that, she asked for incarceration for him not paying an amount that he couldn't get a number from her so that he could satisfy the obligation. But I do think you can prevail. I think there are certainly circumstances where you receive a declaratory action and a court could find, without it being an abuse of discretion, that you were not the prevailing party on it. I think that's a very fact-based question, which is why it's that standard. But in this case, the amount that they agreed was owed was, I think, at most 2% of what Miss Boone was requesting. And I'm going to jump a little bit, because I think one of the...
But before you leave
Sure.
that, I want to make sure that I understand your position. You're going to say that Fanning controls on who's prevailing party here, correct? You're going to say that we have to decide if it was one who succeeded on any significant issue of litigation, which achieves some of the benefit of the
Correct.
suit. So that's what we're working off of.
And in that sense, looking at the big picture of what was going on at that time, Ms. Boone did not prevail on her request for contempt and incarceration. She did not prevail on $250,000. She asked for punitive damages. She asked for judgment interest. She did not prevail on any of those issues that she had requested. So the only resolution there was the agreement, effectively, that it was $5,746.34 was the difference that they could come up with between what had previously been paid and what might have been
And
owed.
is your position on that that's an issue that she might have won on, but not a significant issue? Is that what you're arguing?
I think he won by getting the declaratory judgment. It was certainly phrased that way by the trial court. The trial court didn't say, ma'am, you've prevailed on your counter petition. Her counters were dismissed. And I think at that time, frankly, she was lucky that it wasn't worse given the discovery sanctions that were going on. But they, I believe, announced that $5,746.34 by an agreement that reserved attorney's fees. And I was just going to pivot a little bit. The argument that Dr. Boone is not entitled to the attorney's fees, I think the law is pretty well established that the trial courts have the authority under our discovery statutes to issue sanctions. The trial court was very clear in its argument and went in specific detail its basis for issuing the discovery sanctions that it did. There were multiple instances where Ms. Boone failed to appear for a deposition. It took 17 months to to get the information necessary to get this $5,746.34 number out of her. Dr. Boone spent almost $50,000 just trying to obtain that number so he could pay that. I can't imagine that there is any purpose for that other than to try and extend litigation and to cost Dr. Boone money and hardship. This was a very nasty post-divorce action.
It was nasty, but there was no objection to the attorney fee affidavit filed by both parties.
There was not.
Okay.
There was no argument that it was unreasonable, and Ms. Boone did get her own fee award for defending a motion for an accounting that offset the original award of $51,000. The court's finding that it was reasonable has not been challenged at the trial court level. I don't think it was brought up here, and I think that should stand as a simple discovery sanction. In a case like this where we did have a non-suit of a claim, we did not have a non-suit of the case in its entirety, so a discovery sanction would stand. That was actually something that I got a little paranoid about when I was doing this brief was, you know, there's some confusion in the case law about voluntary non-suits and a sanction surviving them. But in this case, because we had these two actions, and actually the declaratory judgment had been adjudicated, and I think the trial court was right to set everything, right, last things that you all have, we're gonna hear them all on this date, let's get the attorney fee motions in. I frankly think that Ms. Boone is probably a little lucky that Dr. Boone didn't pursue more attorney's fees. There's a clear order from the court after the declaratory judgment that says, you know, we're gonna start awarding attorney's fees to prevailing parties. That's a court order, and then the court declined to do that at the end of this case. So I think here this should be, as far as these things go, relatively straightforward. Ms. Boone, as the court put it, flagrantly violated the discovery laws. She was sanctioned as a result of that. The declaratory judgment was adjudicated, and the remaining issue that had proceeded was voluntarily non-suited. Any attorney's fees relating to the litigation for the voluntary non-suit, I think I think it'd be hard to say that you are a successful party on that issue when it was non-suited. I do think that successful and prevailing should be used interchangeably here, just as it was in their petition. And I think that the discovery sanction would survive that, and it wasn't challenged on its reasonableness.
Thank you.
Thank you.
Rebuttal, Mr. Preston.
Thank you, Your Honor. You know, I would just point out that I fail to see, respectfully submit that when a party brings an action and they end up paying money, they're not the prevailing party. Whether it was brought in the form of a declaratory judgment or whether it's another sort of claim, Dr. Boone underpaid when this matter was originally filed, and he admitted so, essentially, and paid.
But are these two separate actions?
They are.
Was the second one a completely different docket number and?
Yes, Your Honor.
Somewhat different issues.
They were different because what happened was Dr. Boone was facing having to give his deposition, which he didn't want to do, and Judge Martin was our judge at the time, and he put down an order and said, you're gonna either pay this amount, what you believe is the correct amount, and he asked both of us to submit it to him, and if there's a problem, you can bring it back before the court. Well, he paid a significant amount. It wasn't the whole amount. And we decided rather than to continue with the litigation, these parties have children. They're adults now, but let's just not say you've been paid a substantial amount of your amount, but it's not all. Let's just, we'll just non-suit, which is what we did after she was paid. And then he filed the declaratory judgment action after that had been dismissed. And so at that point, now he's coming back and saying, I don't owe any money, essentially is what his argument was. And, you know, ultimately after we went through the discovery, and I disagree with the characterizations of what happened through the discovery, but be that as it may, the court, and it wasn't Judge Martin, those orders, most of those orders were where the attorney's fees were reserved under Judge Martin, and then Judge Hood ruled on them later, even though she wasn't the original judge. But on this case, Judge Martin retired. But he admitted and essentially conceded the payment of additional money for his alimony and unpaid child support. And that was the amount he paid. And so respectfully, I respectfully submit that that does not constitute success for Dr. Boone nor prevailing. And there is a distinction, respectfully. I submit that the word successful should be interpreted differently than prevailing. They are synonymous, but not completely. And so, based on that, I ask your honors reverse the case, remand it to the trial court for further calculations.
All right, thank you, Mr. Preston, and Ms.
Thank you, your
Smith,
honors.
for your arguments. We will take it under advisement. Call the next case, please.
Poser Investments, Inc. versus Old National Hospitality Company